right, sir, you're John Jones?
Yes, ma'am.
Give me just a second. Let me get your, everything pulled up here. See, Mr. Jones, in cause number 25 DCCR 0523, you're charged with a first-degree felony offense of murder from April 28th of 2025. Sorry, blunt one. And what that means, sir, is that if you go to trial and you're found guilty in that offense, the range of punishment would be between 5 years and up to 99 years or life in prison. Do you understand the range of punishment?
Yes, ma'am.
And then in cause number 24, DCCR 2431, you're charged with a state jail felony offense of unauthorized use of a vehicle from October 15th of 2024. What that means in that case is that if you go to trial and you're found guilty, the range of punishment is between 6 months and up to 2 years in the state jail prison. Do you understand?
Yes, ma'am.
And then in cause number 25, DCCR 1352, you're charged with a first-degree felony offense of aggravated robbery from September 18th of 2024. What that means in that case is if you go to trial and you're found guilty, the range of punishment is a minimum 5 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
And then finally, in clause number 25 DCCR 1353, you're charged with the second-degree felony offense of robbery from September 18th of 2024. And in that case, what that means is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
And then I have here on the tablet, in those cases, some plea bargain rejections that you've signed with Mr. Wilkerson. They show that the district attorney's office has made an offer, if you wanted to enter pleas of guilty, for a 35-year term in the murder case to run concurrently with a 35-year term in the aggravated robbery case, with a dismissal in the robbery as well as the state jail felony unauthorized use. Is that correct?
Yes, Your Honor.
Do you understand what their offer is?
Yes, ma'am.
And have you gone over it with Mr. Wilkerson?
Yes, ma'am.
And do you want to reject that offer and have all 4 of your cases set for trial?
Yes, ma'am.
All right, is there any reason to expect that those offers would change any evidence that you're waiting on that you guys haven't received or gone over?
No, Your Honor, not at all. In fact, the state will be, will likely be filing a motion to accumulate the sentences to the extent that we can. I think 3 of them would come by one occurrence, and then there's 1 from a separate occurrence.
You've actually got 3 different dates. So you've got ag robbery and robbery from September of 2024. You've got an unauthorized use from October of 2024, and then the murders from April of 2025.
To the extent we can accumulate all of those, Judge, we will seek to do so.
So I want to make sure you understand, Mr. Jones, that if you are found guilty in more than one of these offenses by a jury, the state can file requests that I stack or run cumulative, which means stack on top of each other any punishment that you receive. Do you understand that as well?
Yes, ma'am.
And that after today, I will not accept this agreement for a 35-year term. If you change your mind later, you can enter a plea open to the court. You can enter a plea to something different, but it's not going to be 35 years. Do you understand?
Yes.
All right, and do you want to have all of your cases set for trial?
Yes, ma'am. I got a question though.
Yes, sir.
Like, it's my offer 35, right? Like, that's what the DA's offering, right?
Uh-huh.
My co-defendant admitted to it, but he got a 30-year off.
Here's the thing. Your offer is what your offer is. He may or may not have had the robberies before he would, listen, I don't know. I know the offer is what the offer is, all right? So either you take the offer or you go to trial and let a jury decide. I'm not involved in negotiations. I'm not going to tell the district attorney's office what to do. That's not my job. But you don't get to, everybody has different issues in their cases that they feel important and why they would make different offers for different co-defendants, all right? So you're not going to have a different offer, and that's what I want to make sure you understand. Even though there was something different for your co-defendant, the district attorney's office has said, this is it, this is your offer. Do you understand?
Yes, ma'am.
Okay, and you want to reject it and go to trial?
Yes, ma'am.
Okay, we'll get it set for trial, and Mr. Wilkerson will be in preparation. You can go back with the bailiff.
Thank you, Your Honor. Be excused.
Thank you, sir. or entered pleas of guilty in cause numbers 25 DCCR 1106 and 1108 to the first-degree felony offenses of aggravated robbery. The agreements were for 10-year deferred probation and $500 fine in each. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, I have, Your Honor.
Are there any additions or corrections?
Not from the defense.
No, Your Honor.
So, obviously, Mr. Briones, this gives me a lot of concern based on the nature of these offenses. Another thing that I make notes in your pre-sentence report, and one of the things that I have found continuously happening in cases with young people your age, you're 18? Okay, so everybody says they're hanging out with the wrong crowd, right? But everybody can't be hanging out with the wrong crowd. You've become the wrong crowd, right? And so if I give you this opportunity today, then this is the best opportunity you will probably ever get in your lifetime, because you will be able to live your life, hopefully, in a very different way than you were on that night, and the way you were going down that road as a juvenile with stealing cars, right? Why didn't you finish school?
Because I kept being sent to my alternative campus.
Because you kept getting in trouble, right? So part of your probation is going to be that you get your GED, and you're going to get it soon, because that's hopefully you should want to get that, because it's going to help you be more successful in life, but it's going to be a part of your probation. You understand?
I'm in the program already. It's just waiting on me to go.
Okay. And I know that ISF Cognitive was not a part of this plea agreement, but that is what's going to happen today as well, and I'll explain that more. I'm going to find, Mr. Briones, that you entered your pleas of guilty in each of your cases freely and voluntarily. Find sufficient evidence to find you guilty. In cause number 25 DCCR 1106, follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 10 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation, and I'm going to go over some of those in just a minute. And cause number 25 DCCR 1108, also find sufficient evidence to find you guilty, but follow the agreement and defer all proceedings and place you on probation for 10 years. You're also ordered to pay the $500 fine and to follow all of the rules and conditions of probation. One of those conditions in each of your cases is that you will enter and successfully complete the cognitive track of the ISF program. That is a 90-day program. That is, you'll go from jail to that program. And it is a program where you receive tools to help you make better decisions. You're young. You're going to have to be making very adult decisions if you're going to keep yourself out of prison, and that's going to help you do that. So what that means is, if I give you that up front and those tools up front, and then you get out and you violate your probation, there's no coming back and saying, oh, I need a second chance. This is that chance. You understand? Also, a condition of your probation is that you have no contact with Deshaun Vital, or Vital, however you say his name, the co-defendant. Obviously, you have no contact with the victims, Leandre Collins and Peyton Mahan. And you're not allowed to possess a firearm at all. Even though you're not convicted, you are not allowed to be in possession of a firearm. That means in the house you live in. So if you live in a home and other people have guns, they have to have them either locked down or out of the house. And probation can come check on that and make sure of it. And if you're caught where there's a place where there's guns, that's a violation of your probation. Can't be in a car with them. You can't have them anywhere. You understand? And so if you do everything that you're supposed to on this probation, again, this is an excellent opportunity, because you don't have the felony convictions on your record. And you will be able to, at the end of the probation, if you're successful, have these cases dismissed, and you'll never be a convicted felon. The other side of that, though, is if you violate any condition of probation, you're brought back in here, found guilty, so you're then a convicted felon, and I can sentence you to prison anywhere in the range of punishment, which is up to, are they first or second?
It's a first year.
So it's up to the rest of your life. It's between 5 years minimum in prison, up to the rest of your life in prison. That's what's hanging over your head. So you have to grow up very quickly and make good decisions like everybody else that's not in prison, or else you'll end up there. You understand? I'm handing you the trial court certifications in each of your cases that shows that these were agreements that I followed, and so you've waived your right to appeal, and so you can go back with the bailiff. All right, good luck to you, sir. Let's
Thank you,
see.
Your Honor.
Thank you. Burton, Bailey, Mr. Rojas. Would you please raise your right hand, ma'am? Do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English?
Yes, Judge.
Thank you. Sir, are you Wilmer Godinez?
Yes.
And will your client waive the formal reading of the indictment?
Yes, Your Honor. There you go, Judge.
Mr. Godinez, in cause number 24, DCCR 2040, you're charged with the second-degree felony of aggravated assault with a deadly weapon from August 29th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they charged you with?
Yes.
I have here on the computer some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Wilkerson?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
I understand.
Also, do you understand, if you're not a United States citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
I understand.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Godinez is not competent?
No, Your Honor.
Mr. Godinez, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 12 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding of a deadly weapon. I'm going to hand you the trial court certification. This shows that this was an agreement that I followed, and so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. That's in Spanish, so you should read it carefully. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or how long that lasts, you can talk with Mr. Wilkerson. Yes, sir?
We've included in that complete paperwork that the sentence in this case run consecutive to the federal sentence. I know you don't necessarily have any control over that. The only reason why we included it is because Judge Crone on the federal side ordered it.
Okay,
So
so consecutive.
consecutive.
Están esperando a ver si el juez judicial federal le va a decir que no. Si no, hacerlo no.
And so, Mr. Godinez, I want to make sure you understand that this sentence will run consecutively with any federal sentence that you're serving. Do you understand?